session. Today we are having 5. Okay, can you hear me? Yeah. Five papers, so I would kindly ask you to be very brief and to stay within 12 minutes maximum, even less than this if you can, so that we could leave some room for the discussion. So I would ask Sandra Marco Collino to prepare her slide, to share her screen, and to start her presentation about a history of competition and the impact of antitrust on Hong Kong's telecommunication market. Please, the floor is yours.
Thank you very much. I am just about to share my screen. First of all, apologies that I appear with the name Ralph van der Lans. It's quite late in Hong Kong and I was going to speak from home, but I have a screaming 4-month-old baby. So I had to come to the nearest office that I could find. So let me see if I can just share my screen with you. Share screen. Okay, that should be.
Great.
I hope if you can't see it, just let me
know
at some point.
Perfect.
Okay. All right. Actually, the paper that I was planning to present at this conference is actually related to telecommunications, which is one of the most recent areas where I've been doing my research. So let me just get straight to the point. The paper looks at the history of enforcement of competition law in telecoms in Hong Kong. And this sector was chosen because it was the only one that had telecoms rules until very recently. So you might be aware that the Hong Kong Competition Ordinance, the first cross-sector law for the city, entered into force in 2015. But Hong Kong had telecoms rules or competition rules in the telecommunications ordinance since the year 2000. And if that was not reflective enough of the uniqueness of the system or how of the sector for how it's seen for the Hong Kong, the citizens of Hong Kong and the government of Hong Kong, currently the competition ordinance contains a merger rule, but it is only applicable to mergers in the telecoms sector involving at least a telecoms licensee. In addition to that, the first case brought by the Hong Kong Competition Commission before the tribunal. So we have this a semi-judicial enforcement system. The Commission investigates a case, and then if it thinks that there has been an infringement, it has to go to the Hong Kong Competition Tribunal, which is the only body that can declare that an infringement actually existed and can impose penalties. So the first case was actually related to the bid rigging practices of various IT companies which were installing an IT server system at the YWCA in Hong Kong. And actually there's been a second case this year also of relating to the IT services of some companies for one of our theme parks here. So that's still pending the outcome. So we see that clearly there is an awareness that this sector is important for Hong Kong, for the economic prosperity of the city. And I guess it's also clear that as a network industry where we have the rule not so many years ago was that of monopolies in pretty much every market, then it needs, let's say, a little bit of a push. Competition has needed a bit of a push to actually flourish and exist. So that's what made me interested in this sector. And I think also, given that we are looking at the digital economy and all the issues, because of the peculiarities, I think that the experience, this experience serves also to maybe foresee what we might see here in enforcement for in this novel area, which we still haven't seen anything in Hong Kong, any developments. So the questions that I ask in the paper are what are the reasons behind the competitiveness of Hong Kong's markets? We will see that they are actually quite competitive. Have the competition law efforts served to tackle the challenges existing in the industry? And if there have been shortcomings, and I will already tell you that there have been, are they attributable to the sector-specific regulation that we had until recently? So they might be solved then by with the new cross-sector law, Or is it that we've had deficient enforcement of the rules that could have been enforced better? So what I've done is I've looked at, I've assessed the level of competition and competitiveness in the markets, in the main telecommunications markets. I've looked at the results of the liberalization process, how the markets now look, and then I discussed the impact of the legislative framework and its practical application on the situation. And then finally, I finish with what we have had to date, what we can see that the competition ordinance has been doing, if there's been any improvement, etc. So effectively, the liberalization of Hong Kong telecoms markets started in the 90s because Hong Kong is a founding member of the WTO.
Eva, sorry, Sandra, sorry to interrupt, but you should actually operate your presentation, because what we're seeing is just the first slide.
Oh, I'm okay, because I can see, okay, it must be stuck because I can see other slides.
You should enable editing.
Okay, let me see.
Enable editing.
Okay.
Okay, now we see the fourth slide.
Okay. All right. So I must have. All right. So you see now the fourth slide?
We see the fourth slide.
Okay. All right. Good, good. So this is the slide that I was on. So effectively, as I was saying, because Hong Kong was a founding member of the WTO, it committed to opening up its markets to competition, including its telecoms markets. There is an annex to the GATS agreement, which relates to basic telecommunication services, and therefore the members, those who signed this agreement, agreed to ensure that there would be access, non-discriminatory access to telecommunications markets, and you know, both or for service providers, equipment manufacturers, and vendors, for everybody. So this is what set the ground for the changes, and in the paper I have a long section where I look at the different markets and how liberalization has been achieved. So just to sum up, because we don't have time, but you can read the paper is already published. So the local let's say telephony, the landline, the fixed calls, the monopoly ended back in 1995, and currently we have the market has almost 30 operators. For international calls, there was supposed to be an exclusivity agreement, so a license exclusively granted until 2006. That was terminated earlier because it didn't make any sense to prolong it so long. The exclusive license ended in 1999, and now we have close to 300 licensees. In mobile telephony, there was never a monopoly. So there was never a cap on the number of licenses that could be issued, and currently there are four more major operators. For internet providers, we have currently about 250, but when it comes to broadband services, we have an incumbent in the market that holds about 60% of the broadband market. And interestingly, the rest of the market is made up by very, very small companies. So we now have a situation whereby there is no limit as to the number of licenses that can be issued by the government. So the markets are open. And I've passed the slide. Can you see the next slide?
Slide number?
Yes,
what number?
It should 5. It's dealing with the existence of market power?
No, we can't.
Okay.
No.
Okay, let me see.
But you have 2 minutes left now.
Okay, so well, basically, the issue is that just removing the licenses was not enough for encouraging competition. So clearly, there had to be more intervention to ensure that the former monopolists would not be able to abuse their power and just perpetuate their dominance of the market. So actually, we had one of the measures that was implemented was that there was some general conditions introduced in the licenses issued to fixed line service providers. And these general conditions prohibited collusion, tying, they prohibited abuses of dominance, and they also regulated pricing and accounting rating of these firms. So they were not able, for instance, to price too low or to give preferential pricing to the companies that they own, just to avoid or to prevent them from giving preferential treatment to their own companies and perpetuating, as I was saying, that market power. As a result of these measures, we have now highly competitive markets, and yet when I think there is a confusion between competitiveness and competition. We do see that there were competition problems in the markets and they were not adequately addressed by the competition authority, even though we did have the telecommunications ordinance with provisions that would have allowed to tackle this. But if you look at the two cases that we had, the two main cases that we had one a case of price fixing against mobile phone operators, and the finding was, well, there was no unfairness and therefore no breach, and this was the evidence suggested that they did actually, they did exchange information to fix prices. And then we have the Banyan Garden Estate case, which was a case of abusing bundling, where the company, well, basically the same the same company that made a residential complex also owned a company that provided broadband services, and the cost of the broadband services with this company that they owned was already included in the management fee and could not be avoided. So if you wanted to get another company, you had to pay that on top of the fee that you were paying, and therefore there was no encouragement to go for those services. But there was, again, the view was there's no unfairness because they had knowledge that they were being advantaged. They had no knowledge, sorry, that they were being advantaged, and they acted competitively, and therefore there was no punishment set. So we see that there were clear shortcomings.
The conclusion?
Yes.
Okay.
So now, since we have the introduction of the competition ordinance, we've had the first infringement decision of the Hong Kong Competition Tribunal, and we also have a new case brought in which the Commission is seeking not just fines for the corporation, but also individual fines and director disqualification. So hopefully the shortcomings can be overcome. So in general, what the problems that pertain are that we don't have hefty fines. The cap is at the moment 10% of a local turnover per year of infringement, capped at 3 years maximum, and we don't have standalone private rights of action. In addition to that, we have had no attempt to apply the abusive dominance rule, the second conduct rule, and no merger investigation so far. So my belief is, my conclusion is that we can solve the issues probably using the new competition ordinance, but we need to address the absence of attempts to tackle abuse and creation of market power for the practical efficacy of these rules. Thank you very much.
Thank you very much. Okay, I would open now the floor to a couple of questions if you have. Remember that you can always write questions on the chat. So I would be interested, if I can myself, abuse a little bit of my, of course, position. Hello everyone, I'm checking whether there are any addressing. Okay, I can see that there are some. Alex, a question at Alex. Okay, a question on your proposed third condition for introduction of, no, sorry, this is from the former panel.
Okay.
No, it has nothing to do. Okay, so I would be interested in, especially, yes, the part in your conclusion. It seems that eventually this new ordinance would change a little bit the landscape, the competition-related landscape. So I would be interested in knowing, in your opinion, how would that happen and in what direction that would be?
Well, so, I mean, the problem that we had earlier was that because, for example, if we look at the Banyan Estate Garden case, so the issue was the market power of this company that owned real estate and telecoms. But we only had rules that could address the telecoms issue. And it was actually a broader issue, right? The market power existed not just in telecoms and probably much greater in the real estate market. So it was clear that we needed that this could only be tackled through cross-sector legislation. The legislation is now there, finally. We need, of course, significant enforcement efforts. And actually, the last few years have been encouraging. So now we have in this area 2 cases, but we also have had a few other announcements of cases in other areas. We have a lot in the construction industry. Well, a lot, at least a number of cases. And I think that what the tribunal has also done, which has been interesting in the fines, in the only fines that have been announced to date, they went all the way up to the 10% of turnover because we already know we have been, let's say, worrying about this cap of the 10% local turnover, maximum of 3 years. So they're trying their best to really send out a message and say, well, actually, you can actually, we're going to use our powers to the maximum capacity. And I think the individual fines and the direct disqualification, the reputational damage that can do, I think, is quite significant. But as I say, what we feel at the moment now is that because there is, in so many markets, there is a significant market power, that perhaps we hope that soon there will be cases under the second conduct rule, under abuse of dominance, which of course are much more complex and difficult. And for a new authority, we understand all the shortcomings, but hopefully this will be the next step.
Okay, thank you so much. Are there any other questions? You can intervene and by raising your hands or just by writing in the chat. If there are no other comments, I would thank you so much.
Sorry, I think we have a question from Aliu.
Okay, thank you.
Oh, yes.
Does consumer welfare form part of your legal framework objective? If yes, how do you measure consumer welfare? May you refer me to any book? Okay, maybe reference to books you can do.
Yes, we can do maybe
privately.
after that. Yeah, sure, we will do that afterwards.
What about the other part?
Drop me an email.
Yes.
So we look, of course, at the different objectives, but I mean, I think consumer welfare, I think it's quite clear that it's one of the main objectives at the moment of Hong Kong competition law. But I think that we don't have a sufficiently developed policy to really know what we are exactly looking at. There isn't really a lot of writings at the moment on this, and there's not a lot. So we need, I think, the policy to develop further to be able to really ascertain whether we are talking about a consumer welfare-oriented competition policy or something a little bit broader than that.
Okay, thank you very much. Now I will give the floor if there are no other questions. Okay, thank you for sharing your email. Thank you, Sandra. I would now give the floor to Yaye Gao, and she will speak about enforcement of the AML in China's digital economy from the perspective of the overall regulatory environment. So again, about 10 to 12 minutes so that we would have a wider discussion. Thank you very much. If you have troubles sharing the slides, I can do it for you. I think I have the last. Yeah, are you there?
Yeah, I'm here. Can you hear me?
Yes, I can.
Okay.
Can you share your slides? Or do you prefer me to do it?
I try to share just 1 minute. If I feel so, maybe I would turn to you for help.
Okay.
I think I am sharing my screen. Can you see my slides? Okay.
Perfect. Perfect.
Thank you. Hello everyone, I'm Yajie from Queen Mary. Today it would be me who presented the paper I co-authored with Professor Han Wei with the name of Enforcement of the AML in China's Digital Economy from the Perspective of the Overall Regulatory Environment, because there are so many points. So I only pick the most controversial or most hatedly discussed topics in China. So I think these are the whole structure of my presentation today. I think it is widely acknowledged that digital economy has become the main driver of the global economic growth today. And the report has it that digital economy accounted for more than 30% of China's GDP in 2018. And since the enactment of China's anti-monopoly law, or maybe we call it AML, competition policy has played an increasingly important role in China. And in order to better understand how anti-monopoly law is applied to China's digital economy, we have to get some knowledge about other Chinese laws and regulations as regards other departments in charge of other regulations. So firstly, I would like to introduce some series of amendments to the department regulations and administrative enforcement and judicial practice regarding AML in China's digital economy. Firstly, it is about some supporting rules for the AML. Since the institutional reform in 2018, the State Administration for Market Regulation, or SAMR, has become the one and only authority in charge of anti-monopoly law enforcement, partly in response to requirement put forward by the digital economy. SAMR has released a series of supporting departments regulations in 2019. Here, I would like to talk about three issues. First is about algorithmic collusion. So, as you can see, the interim provisions about Article 6, it shows elements which shall be considered as regards whether to recognize a conduct as other concerted practice, which is a kind of anti-competitive agreement. What's clear is that communication of intention or exchange of information is one of the conditions. What's not clear is, however, that whether meeting of minds achieved through algorithms could also constitute a kind of other concerted practice. So as regards the dominant market position, this interim provision has also listed elements which could help determine whether a company has dominant market position. Such as the network effects and the lock-in effects and the power to control and process data. As regards the product free of charge, it suggests taking both products free of charge and the products in exchange for monetary payment comprehensively together. And next is about the administrative enforcement in 2019. As you can see that the first case is the Tencent Music Entertainment versus some record companies such as Warner Music Taiwan and Sony Music Entertainment. I think if this case is the first case which is officially investigated by the Chinese Competition Authority in the digital economy, but we can only find source from news report, and I think just recently we can find that this case the investigation has been suspended, and until now no case has been filed to the Chinese Competition Authority in accordance with the publicly available source. And I think, but it doesn't mean that SAMR has done nothing, such as the administrative guidance symposium show here. And I think you can see that the either-or provision, it is the hot topic in the Chinese anti-monopoly law circle. And it means that the e-commerce platform prohibits the registered merchants from trading on the rivals. And As you can see, the symposium means that the authority gathered together a lot of internet companies such as Alibaba and Tencent and alert them as regards the suspected anti-monopoly conducts such as the either or provision and requesting them to rectify relevant conducts. In comparison to the limited administrative enforcement, I think China's judicial system is much more active in this regards. This slide shows all the cases already filed to the Chinese courts. You can see that 3 of them concerns either or provision, and 2 of them, the respondent are Tmall. Tmall is an online shopping platform organized by Alibaba, and it is the most popular one. This one, the dispute between Wende and Didi, it is about the excessive high price requested by an undertaking unreasonably. Among the 4 cases, 3 are pending, and as regards the Luckin Coffee versus Starbucks, it has been dropped by Luckin Coffee. Next, I would like to introduce the regulatory environment of the AML enforcement in China's digital economy. So it is more about coordination between AML and other branches law, as well as the coordination between SAMR and other authorities as regards others. And I also would like to introduce the relationship between the administrative authority and the judicial system. This slide shows the coordination between AML and anti-unfair competition law. We can see I listed the articles which might be applied to one conduct which could also be regulated in accordance with AML. And for most of the cases heard by the Chinese courts as regards disputes in the digital economy, most of them are resolved in accordance with Article 2 of the Anti-Unfair Competition Law, which lists the general principles of the law, such as honesty and good faith and commercial ethics. As regards Article 12, it prohibits undertakings from unreasonably disrupt the other undertakings' online activities through technical tools or other means. As regards the e-commerce law, here I would like to introduce Article 35. It prohibits e-commerce online platform operator from registered merchants from trading with other competitors. As you can see that the either or provision I just mentioned before could be, the dispute could be resolved in accordance with Article 14 of AML, which prohibits vertical anti-competitive agreement, or in accordance with 35 of e-commerce law of the PRC. So there's a kind of discussion in this regard. As for the coordination between anti-monopoly law enforcement with other administrative agencies, here's a list. But I would like to talk about the Ministry of Information and Ministry of Industry and Information Technology. This department has initiated special rectification activities against the illegal products of online undertakings, such as illegal collection of consumer data, harassment, and infringement of other consumer rights and interests. And by December 2019, they have released a list and requesting these companies to stop relevant conducts within a certain period of time. And we can predict that SAMR has to communicate or coordinate with Ministry of Industry and Information Technology when it comes to consumer data or protection of digital privacy. back to the relationship between administrative enforcement and the judicial practice. Here, I would like to mention that conflicts could be found between administrative enforcement and judicial practice as regards whether restriction or elimination of competition shall be proved to recognize the constitution of resale price maintenance. From the administrative side, they think that they think that the such anti-competitive effects doesn't have to be approved. But as for the judicial body, they think that it has to be proved. But in a recent case, which the complainant is Yutai Science and Technology for the Corporation Limited, the Supreme Court for the first time made it clear that for the administrative authority to recognize the constitution of resale price maintenance, elimination or restriction of competition doesn't have to be proved. Last but not least, it is our proposals for pushing forward the application of anti-monopoly law to China's digital economy. Here, I would like to talk about, for this one, about the innovation in accordance with the latest draft amendment to AML. Thank you. In January 2020, it introduced encouragement of innovation as one of the new purposes of anti-monopoly law. And it not only reflects China's encouragement of the nascent industries such as the internet, but also has aroused a widespread discussion, especially whether the anti-monopoly law shall be efficiently or properly applied to concentrations in the digital economy. Especially, I think during the two sessions of 2017, the Chinese government proposed the so-called tolerant and prudent principle to regulate new industries. And does it mean that the anti-monopoly law doesn't apply to concentrations in the digital economy? I don't think so, but it depends on how we should apply it. So that's my presentation. Thank you very much.
Thank you very much for this very wide presentation that touched upon a lot of points and a lot of very interesting points. Let me check whether there are any questions. Anyone who would like to intervene, please feel free to do so. You can raise your hand. There should be, you should be able to see the button raise hand. Otherwise, I would again abuse my position to ask you about this promotion of innovation clause, which is being, if you could stay on this slide.
Okay.
Yes, I think this was your last slide. Yeah, the promotion of innovation that has just been introduced, as far as I understood, in the protection of competition law, which sounds to me very interesting. But I ask myself, to what extent does this clause or could this clause come to conflict, or could come to conflict with the promotion of competition? Because innovation might require heavy investments to promote to have innovation, which might require to have big size and to have big tech, while on the other hand, as we have seen from yesterday's keynote speech by the European Commissioner, eventually this might stifle innovation, especially from new enters.
Okay, so The reason why I would like to talk about encouragement of innovation to one of the new purposes of the AML is because I think maybe we need to understand this against the macro background. So as I mentioned, the tolerant and prudent principle to regulate nascent industries. So as regards how to understand the tolerant and prudent principle, it means that when the authority is confronted with something new they have never met before, maybe they just would wait and see as regards what it will develop into, as regards and consider how and whether they should regulate such kind of new things in the society. As regards innovation, I think innovation could be reflected in many ways, such as which could also mean higher quality of products for consumers. And I think it is which means that more consumer welfare, and I think it is a widely legislative purposes of competition law or anti-monopoly law. So as regards to the innovation, and the reason why there is such huge controversies in China is because until now, the Chinese Competition Authority hasn't done very much as regards anti-competitive conducts of the internet companies, and a lot of academic scholars, they think that it's not enough, and actions should be undertaken. And if we would like to introduce encouragement of innovation to one of the purposes of anti-monopoly law, does it mean that the authority would more prefer let the nascent companies to develop instead of intervening in due time, or they should just take actions just in time? So that's the reason why I mentioned it here. And I'm not sure whether I have answered your question.
Yes, absolutely. Thank you very much.
Okay. Thank you.
Are there any other questions? Yes? Please don't be shy. Okay, if there are no other questions, thank you. Thank you so much to both of you. I don't know whether Han Wei is with us today in this beautiful panel.
I'm not sure. He is in China now. And,
okay.
Okay, I will talk with him about feedback as regards my presentation.
And congratulate with him for the paper and for your presentation. Thank you very much. Okay, so next paper is by Miguel Souza-Ferro. Miguel, are you ready with your presentation? Would you prefer me to?
Yeah.
Okay.
No, I think I should be able to.
Okay, great. So let me introduce just one word. Miguel is professor at the University of Lisbon Law School and at the Universidade Europeia. He will present a paper on antitrust private enforcement and the binding effect of public enforcement decisions. Again, since we have few minutes left from the previous discussion, you will be awarded 2 more minutes. Therefore, instead of just 15 minutes, you will have 17 minutes. The floor is yours.
Thank you so much. I will try to leave that time for debate, if possible. The presentation that I am doing today is a presentation which is based on a paper which I have submitted and that you can have access to through the ASCOLA website. You can also have access to this presentation. So I will not go into the details of everything that is mentioned in the presentation and the paper, and I would just like to talk to you about some of the larger ideas and messages that I think I came across as I did this research. So I'm going to divide our discussion. The first division that is important is to decide, it's not the same to talk about European Commission decisions or to talk about NCA decisions. Then I'll look at the material scope, subjective scope, and temporal scope. Brief mentions of the obligations of national courts in case of infringement decisions that are not yet final or there are still investigations ongoing. And then we'll look at some of the things that are sometimes a little less forgotten in terms of the binding effect of public enforcement decisions, which is decisions in state aid, merger control, and commitment decisions. And if there's time, some notes about how we might get out of this binding effect. So the first thing I would like to stress is that this binding effect of European Commission decisions, we tend to think about Regulation 1/2003, but that is very short-sighted. The binding effect of EC decisions comes from master foods. It comes from the case law of the court, and I put that case law there. And it has been partly codified in Regulation 1/2003, only partly. And we cannot just use Regulation 1/2003 because it's the case law that really explains to us the teleology behind this binding effect and allows us to clarify issues which, if we just looked at the regulation, we wouldn't understand. And so I would like to make clear that a lot of the conclusions that I present here are based on the case law and not on the regulation. So for example, we know that the regulation doesn't tell us that there is a binding effect only when the decision has judicata, but of course that has to be the case. There can't be a binding effect before the decision is has judicata, and we'll see how that is addressed. That's a non-final decision. The case law also allows us to conclude that this binding effect must apply to negative declarations, meaning, and there really has only been one in the history of EC enforcement, as you know, and it's been now because of COVID. So if the European Commission, and it is only the European Commission, not the national authorities or national courts, makes a negative declaration concerning 101 or 102, that would also be binding, a declaration that there is no infringement. As I said, that is incredibly rare. And then when we look at the binding effect of NCA decisions, we have to differentiate between that which already existed before the damages directive and continues to exist through general principles of EU law, and that which now exists under the damages directive. And of course, the solutions varied a lot between the member states. But the case law already provides some clarifications about this, and there is a pending referral now in the Repsol case, which will allow further clarifications about the binding effect of NCA decisions, regardless of the directive, right? Before the directive and even after the directive, just from general principles. But essentially, it seems that we're probably going to end up in the NCA decision under EU law must constitute an indicia, must constitute a rebuttable presumption. That's what it looks like we're going to end up. And that is a very harmonious solution, for example, with the case law solution for commitment decisions. And of course, then under the damages directive, I think we all know what happened there, so I'm not going to be wasting too much time on this. We've moved forward to an irrefutable presumption for NCA decisions when it's with the NCA of the same member state, or for a refutable presumption for NCAs of other countries. And Germany has gone even further than that, and it created, just as it had before, continues to have an irrefutable presumption, even for decisions of other NCAs. But these situations don't come up very often, but they do come up, and we have some examples mentioned there. By the way, when we talk about when a decision becomes final, it's very important to be careful about what that means. Of course, a decision is final if there is no appeal, but it's also final for this purpose if there is an appeal, but not on the infringement, right? If a company only appeals on the amount of the fine, the decision is final in what concerns the existence of the infringement. Then there is the subjective scope of the appeal. It's final for one undertaking, but it might not be final for the other undertaking that appealed it. And then there is the really complicated issue of the ordinary appeals. The directive opened this can of worms, no idea where this is going to end, but basically you might have a decision overturned by a constitutional court, and under the directive, the private enforcement court was already bound irrefutably by the decision. So it might have said that, oh, I'm bound irrefutably, and in the meantime, the Constitutional Court annuls that decision. Very bizarre situation that the directive created there. As to the material scope, this has been looked at already in some decisions. I would refer you to the brilliant judgment of the Competition and Appeal Tribunal of 4 March 2020 in Royal Mail, where it really goes into detail in a very really well justified analysis of what are the parts of a decision that are binding. And the idea there is that it can't be just the operative part, because most of the times you don't even understand what the infringement is, just looking at the operative part. So it has to be the infringement declared in the operative part, plus whatever components of the recital are essential to understand the infringement that has been declared in the operative part. And the court really breaks that down and goes paragraph by paragraph to discuss what are the parts of the decision. Yes, Fabiana?
2 minutes.
2 minutes? I've been speaking for 7 minutes. Okay.
I must have miscalculated something, but please go ahead.
I set my chronometer. I was speaking for 7 minutes.
I'm sorry.
Okay, so, but I will try to speed up. So the material scope continues with, there are superfluous findings that will not be binding. So for example, if there is a quantification of damages, that quantification of damages is not relevant for the finding of infringement, if we're talking about an object restriction, especially. And so the quantification of damages itself will not be binding on the follow-on court. And then there are a few other really detailed discussions that we can have about the 102 positive economic test, about the 1013 assessment, but we don't really have time to go into that. So what do the claimants still have to prove? They have to prove that there is a presumption that there is damage. If it's a cartel, there's a presumption of passing on, but you still need to prove damage and causality beyond or outside the scope of those presumptions. Then there is a subjective scope, and this really is an open issue. My position on this is that the principles set out in Master Foods and the other case law mean that the EC decisions are binding erga omnes. It's not just binding on the person to whom it is addressed. It is binding on every other person, even outside the economic unit. And the reason for that is that the justification that the court gave for the creation of the binding effect has to do with primacy and exclusive powers of the European Commission. It has nothing to do with the exercise of the rights of the defense, and it's not dependent on that. Of course, this will raise complicated issues, but this is what I believe is the result of the case law. And we also enter into a gigantic minefield when we look into liability of cartel members, joint liability for an infringement when one of them appealed, the other one didn't. The temporal scope is also a complicated issue. There's, of course, the infringement itself. The temporal scope might vary and the binding effect might vary. We shouldn't assume that just because a decision says that an infringement occurred between X and Y, that the affected sales are between X and Y, because maybe the effects only produced sometime after the infringement began. Right? It depends on the market. Maybe it only ended sometimes after the infringement. It depends on how the market works. So a lot of attention is going to have to be paid. For example, in the trucks cartel has already come up with this temporal scope of the sales that are affected by the infringement. If we have a non-final infringement decision, fundamentally here what we have is the duty of sincere cooperation. If the EC decision has been adopted but is not final, the court cannot decide that the infringement does not exist, because that would be contradicting the decision. And it should do its best to avoid contradicting the EC decision. So it can either suspend the proceedings and await the decision or at EU level, or it can refer a question to the ECJ. And I have to speed up. In state aid, please mind you that there are already a few precedents on the binding effect of state aid decisions, and people usually forget about this. And this is also some of the cases that I turn to justify my conclusion about the erga omnes effect. In merger control, there are no binding effects yet. There are no precedents yet on binding effect. but I believe the logic of the other cases applies by analogy. One area which was very surprising was the case law on commitment decisions. Basically now the outcome is that a commitment decision, or better yet, the statement of objections which preceded the commitment decisions, the infringement identified in that statement of objections creates a rebuttable presumption of an infringement. That was really interesting. I don't think a lot of people saw that coming. And that has to do with the case law of the court when about appeals of commitment decisions themselves, where the court said that, yeah, sure, this doesn't declare an infringement, but for a commitment decision to be valid, for us to be able to control it, we have to know that it doesn't go beyond what is necessary to resolve the infringement. And so it has to there has to be an infringement properly identified, right? So it was because of this logic that the court said, commitment decisions do produce binding effects, but it's just an irrebuttable, a refutable presumption. Yeah, and then just a few comments. This, of course, there will be many discussions of many challenges to this binding effect, and many people will, for example, want to appeal to constitutional courts, to the ECHR, and there will be ongoing disputes with the ECJ in this regard. There will be people invoking the limits to the primacy of EU law. So there are several ways that you might try to get out of the binding effect of these decisions, but they are limited. And one of the important things to keep in mind is that you really can't dissociate between the discussions, or there is a bit of a difference, but fundamentally the constitutional and fundamental rights issues are the same, regardless of whether you're discussing EC decisions or NCA decisions. So there, it's surprising that this has only become a huge problem now, whereas it already existed under the Regulation 1/2003 and under master proofs. And with that, I conclude. Thank you so much. Fabiana?
I'm sorry. Okay, thank you very much for this very interesting presentation. And I would now open the floor to questions.
Okay, I see a question. I see 3 questions, I guess, from Francisca. Did you come across the alleged lobbying by cartelists to include as little information? Oh yeah, of course.
How come that you can see questions and I don't? This is weird.
It's in the chat. It's in the chat.
Yes, I am in the chat, but I cannot actually see any.
Okay. Well, Francisca asked, yes, this is one of the problems where companies are trying to, infringers are trying to get around their fears of having to pay compensation by negotiating the content of the decisions. And it's happening everywhere. For example, in Portugal, we recently had an insurance cartel where the infringers were so successful in negotiating the content of the decision that, to be fair, the competition authority, even in a decision that wasn't negotiated, also did the same problem. But anyway, they were so successful that you don't even understand what the infringement is. It's described in such a way that you don't even understand if you were injured by it or not. It says affected large companies, and it doesn't decide what doesn't identify what a large company is. So that is a huge problem, and competition authorities need to think about what their obligation in this regard is. At most, in order to protect private enforcement, which is also one of their objectives. Marcos says, would the identification of the liable entity in the public enforcement decision bind the court in the follow-on case? So
okay, now
I think I already,
yeah, right.
I think I already addressed.
Okay, and then I'm interested in the reasons why, the Damages Directive Article 9.2 did not eventually grant binding effects to the final decision. Can I answer first
Marco's question?
Yes, which one?
Just to answer Marco's question. So the fact that an entity is identified as liable doesn't, as I said, it doesn't. First of all, the liable entity is the economic unit, not the legal person. So under Skanska, the liability will ascribe to the entire economic unit. That's my position, not just to the legal person identified in the decision. And then you also have the problem of, if it's an EC decision, you have the erga omnes effect And there, this issue disappears altogether. And Penelope, why damages directive at Article 9 did not eventually grant binding effects to the final decisions of other member states. Yeah, so this is one of those sad aspects of the negotiations between member states. It's very clear why this happened, and it popped up again in the transpositions. Every member state except for Germany decided not to go further. Why? Because member states don't trust the authorities and courts of other member states. Basically, that's the reason. It's very sad. It shouldn't be this way in the European Union. I'm not going to say that it doesn't have any bottom, that there is no bottom grounding for this concern, but it shouldn't be this way.
Okay, you want to go further? No? Okay. Are there any other questions? Yes? No. Okay, let's move on then. Thank you very much, Miguel, even for addressing the questions and also for sustaining my functions. And then let's move on with Penelope Josa, lecturer in law at University of Portsmouth in the UK. She will present a paper on preventive collusive tendering in framework agreements. Thank you for sharing your screen. You should enter your presentation. Penelope?
Can you hear me?
Yes, now we can hear you. We can hear you,
Great.
yes.
Good afternoon. It's a great pleasure to be with you in order to discuss my paper on collusive tendering in public markets. Public procurement and competition law are two distinct areas of research with different priorities, different concerns. However, in my opinion, it's worth examining both of them, especially when it comes to anti-competitive activities like bid rigging. And the focus of my presentation today is on the framework agreements, because it has already been underlined in the literature that bid rigging may arise particularly in the context of framework agreements. I understand that most of competition lawyers and academics are not very familiar with this concept because it comes from public procurement. So I would like to spend a few minutes in order to explain what framework agreements are. They are a flexible tool for aggregated procurement. They are agreements between one or more contracting authorities and one or more economic operators. And their purpose is to identify a limited number of suppliers which have the best offers to conclude a public contract with the procuring entity in the future when a particular need arises. In this way, the award of multiple contracts by only a single contracting authority is possible without having to repeat each time the same or similar tendering processes. At the same time, contracting authorities' buying power gets greater, which is very important when you deal with powerful firms in the market. The term of a framework agreement shall not exceed 4 years, save in exceptional cases duly justified. And now let's talk a bit about the standard steps that are usually taken in a framework agreement. First of all, we need an invitation to economic operators to participate in the procedure, which describes the procurement entity's needs, the terms, as well as the conditions of the procurement. Then we have the selection of one or more suppliers, which was made after the assessment of the economic operator's qualification and responses. And then the procurement entity enters into a framework agreement with the selected suppliers, and it places orders with these selected suppliers as soon as a particular need arises, following a mini competition among the economic operators, which are parties to the framework agreement. This is the call-off stage, and this stage is very problematic, as you will see in my presentation. So despite the aforementioned strengths that framework agreements have, there are also several pro-collusive features. In my presentation today, I'm going to focus on two pro-collusive features. The first one is the closed nature of framework agreements. As soon as framework agreements are concluded, it is impossible for new tenderers to take part in the process and enter into the agreement as orders are placed by reference solely to the tenders submitted by the suppliers that gained access to the framework. Even if there are great discrepancies between the prices required by the potential framework suppliers and the relevant market prices, it is practically difficult for a contracting authority to address to new contractors outside the framework agreement. So this automatically creates a high barrier to entry, which limits the market for the subject matter of the framework agreement at issue, since outside competitors are excluded from it for the whole duration of the framework agreement, which can be maximum 4 years. These circumstances are common and known to economic operators each time the procurement technique of framework agreement is used by the procurement entity. Consequently, the firms that enter into such an agreement are aware in advance of their interdependence, as well as of the fact that no matter what, their number and composition will remain fixed throughout the duration of the framework agreement. The recognized interdependence and the high barriers to entry are the necessary preconditions, as we all know, for an oligopolistic market. In an oligopolistic market, the supply side is concentrated in the hands of relatively few firms, and for this reason, the danger of bid rigging is apparent. Likewise, in a closed framework agreement, the market can be characterized as static and oligopolistic. And this is particularly true as, in practice, the average number of suppliers with whom a multi-provider framework is concluded is only 4. Coordination becomes feasible in view of the small number of market players that will be known to each other, assuming normal transparency mechanisms apply in the procurement procedure. Let me remind you here that transparency is one of the principles that is well respected in public procurement. An illustrative example is the one in Norway among Aero, Caverion, and Petersen firms. This bidding ring was facilitated by the limited number of these 3 competitors in the tenders of a 3-year framework agreement. So my suggestion regarding the pro-collusive feature regarding the closed nature of framework agreements is the openness to new joiners. A level of new entrants should be allowed when bidding for call-off contracts at the second round of competition among the parties to the framework agreement. Yet this suggestion may raise concerns in respect of transaction costs and the firm's incentive to enter into a framework agreement in the first place if they know beforehand that new joiners are to be expected. For this reason, my recommendation is that new entrants should be allowed only if the following conditions are met cumulatively. Firstly, there should be divergence of the prices asked by the bidders admitted to the framework agreement at the first stage of the procedure and when the need arises. And secondly, there is discrepancy between the prices required by the awardees in the framework agreement and the prices asked by the suppliers in the market outside the framework agreement. If the divergence of the prices asked at the first stage of the procedure and when the need arises is due to, for example, some market shocks or demand fluctuations, then the prices asked by the suppliers in the market outside the framework agreement will also change. So market prices are a reliable benchmark before deciding whether the divergence of prices asked by the framework awardees is justified or not. However, in case of price discrepancies, it is exceptionally costly, time-consuming, and difficult for the contracting authority to hold a wholly new tendering procedure together with a new official journal advertisement in order to seek improved value for money from new contractors outside the framework agreement. For this reason, framework awardees should have the possibility to improve their offers. At the same time, framework awardees will know that if they don't keep their prices at or below the commercial prices at the call-off stage, a cutthroat competition will take place with the involvement of new entrants in the framework agreement market. Price revision clause is my second suggestion. Another way for a contracting authority to ask for changes to the prices submitted for the framework without a new procurement procedure. This is the provision in the framework agreement for a price revision clause. However, the drafting of such a clause must be clear, precise, and unequivocal. Otherwise, there is always the risk that the contracting parties may interpret it differently. And in such a case, the relevant contract term may be submitted to arbitration or jurisdiction, which is a quite costly and time-consuming procedure for public sector. Moreover, the inclusion of price revision clauses may bring additional costs to procurement entities, because usually a form of retainer must be paid to a framework supplier in order for him to remain capable to deliver at all times under the framework agreement, despite the risk of fluctuations in the market. And now let's deal with the second pro-collusive feature of framework agreements: homogeneity among procurement contracts and the fact that competition at the call of states is mainly price-driven. As already explained above, when a particular need arises, the economic operators, which are parties to the framework agreement, take part in a second round of competition in order to contend for the public contract. Normally, all technical dimensions of the product or service are let down in the master contract at the first stage of the procedure. So the only remaining variable at the second round of competition among the parties to the framework agreement is the quantity to be purchased at the call-off stage. This connotes that call-off contracts will be homogeneous and they will vary only little from each other as far as quality and technical characteristics are concerned. Products that do not differ in terms of an intrinsic attribute like quality do not present product differentiations. Product differentiations can be assimilated to cost asymmetries because a firm that offers a better quality is situated as if it were enjoying a cost advantage. In the absence of product differentiations, potential suppliers participating in the second round of competition do not differ in production costs, and so they will find themselves bidding in a cost-symmetric environment. Cost symmetry is deemed to enhance collusion because the problem of agreeing to a common pricing policy can be easily overcome. As a result, competition at the second stage of the framework agreement procedure will be primarily price-driven, and if the potential suppliers want to collude, it will be rather easy for them to agree on a common pricing policy. So my suggestion is, first of all, the use of the most economically advantageous tender criterion. Instead of using the lowest price as the only criterion for the award of public contracts under framework agreement, contracting authorities should opt for the price-quality ratio version allowed under the most economically advantageous tender criterion. By asking from suppliers technical requirements that ensure a specific standard of quality for the products procured, it is like introducing product differentiation, which increases the asymmetry between firms, as their production costs will differ. Asymmetry between the number of suppliers and the number of call-offs is my second suggestion. The contracting authorities should ensure a degree of asymmetry between the number of suppliers and the number of call-offs so that any colluding framework awardees may find it difficult to coordinate and share the pie between them. In practice, the average number, as I said before, of suppliers with whom a multi-provider framework is concluded is nearly 4. So before determining the number of call-off contracts, it is good for the relevant procurement officers to make themselves aware of this empirical evidence and determine accordingly the number of call-offs. And my last suggestion is the adjustment of the contract's value to the framework awardee's level of symmetry or asymmetry. Apart from the number of call-offs in the context of the framework agreement, it is also the value of the contracts awarded at the call-off stage that enhances or decreases the risk of collusion between the framework awardees. Symmetric suppliers, in other words, firms that have similar bargaining power, are more vulnerable to making collusive agreements between them when the contracts awarded at the call-off stage are similarly valued. This is because it is easier for them to allocate the contracts between them. The same applies to asymmetric suppliers when the contracts awarded at the call-off stage are differently valued. For this reason, the relevant contracting authorities are recommended to adjust the value of the contracts awarded at the second stage of the framework agreement to the level of symmetry or asymmetry that the framework awardees have as far as their bargaining power is concerned. When the framework suppliers are symmetric, in other words, the value of the contracts to be awarded should be different from each other, while in case of asymmetric framework suppliers, the value of the contract should be similar to each other. So after this brief analysis and presentation, we can see that the framework agreements are not the best possible toolkit for preventing anti-competitive practices. Therefore, contracting authorities should use this procurement technique wisely and in markets that are not susceptible to collusion. Thank you very much for your attention.
Thank you, Penelope. Thank you very much for your very nice presentation. And I open the floor for questions. Thank you for this I like when presentations are interdisciplinary in the sense that they cross over disciplines between competition law and different different kinds of disciplines, like in your case, bid rigging, or like telecom law, like in previous presentations. I really much like these efforts of trying to apply competition rules to sectors, to specific sectors. And I think you did a very good job in doing this effort of trying to see whether competition rules do suffice, or we need special tools, or whether regulation per se does suffice to tackle the competition problems, while at the same time coping with their sector-specific or let's say topic-specific problems, like in your case. So, okay.
There is a really interesting question by my colleague Vicente. Yes.
Vicente, okay. I'm about your opinion. Wouldn't the traditional framework agreement a way to contribute to vertical collusion and so relate competition issues with corruption and bribery? Wow.
Yeah, absolutely, Vicente. Your question is to the point, and this is why actually in public procurement they go for a lot of transparency in whatever they do, because they are afraid that public officers may be bribed by firms that are usually the ones that undertake the supplies and the supplies of the public supplies. So yes, of course, it is a way to open transactions between the public officers and the firms, especially if we take into account the fact that these framework agreements last for nearly 4 years. So, and even the call-off contracts, the separate contracts between the procurement entity and one of these firms, may be renewed for even more years if there is need to, sometimes. Is there anything else that you would like to discuss? Because your question is quite open, and there is a lot of things to say about this issue. But if you want to be more precise,
okay, I can step in here, because sometimes transparency can run counter competition. I mean that when markets are too transparent, there can be room for collusion. And therefore, even where CEOs of companies might have the possibilities of getting together too much, or whether on the markets there is too much visibility as far as the strategies companies are taking, or whether there is too transparencies as far as the structure of prices. We know all these theories. So don't you think that while we are increasing transparency for the sake of bribery reduction, we are at the same time increasing the risk of collusion?
Definitely. I totally agree with you, and this is the great challenge of those who are active in both areas of law, public procurement and competition law. And Professor Kovacic is one of those who have made a great number of suggestions in order to be able to balance, on the one hand, transparency, and on the other, the danger of bid rigging in this area of law. So a possible suggestion is to give out as little information as possible to firms about their competitors, with whom they compete, what is the magnitude of the contracts to be procured, because if they know beforehand the size of the contracts, the duration of the contracts, the specific nature of the contract, they can prepare themselves more easily to come into an agreement with other firms. On the other hand, however, they need to know, firms need to know what they are going to procure for in order to be able to decide if a deal with the government is the best for them, or they may not want to take part in a public tender. So the balance is very fragile here. And this is why I cannot give a simple question like yes or no. There are some parameters that policymakers should take into account, and this is what I'm doing. I've done in my thesis. I have made a careful list of suggestions to policymakers, parameters mostly that they have to take into account before proceeding.
Good, thank you very much. Okay, then I will switch to the last, but obviously not least, presentation, and would ask Eva Fischer to prepare. Eva is doctoral fellow at Ludwig Maximilian University in Munich and will present on the reach of corporate entity liability and its economic foundations. Very promising paper, always in this wave of intersecting different parts of law. Eva, okay, please, when you feel.
Good afternoon. Can you hear me and see the slides? Is everything all right? Okay, perfect.
Everything is perfect.
Thanks for having me today. I really appreciate the opportunity to present at this great digital conference. What I'm going to talk about today is corporate entity liability, and thereby I mean the liability within private and public enforcement procedures. We already touched upon this topic several times throughout the conference, especially in yesterday's morning session. And even Miguel just tipped on it in referring to the Skanska judgment. But I still hope that I might bring something new to the table at the very end of this conference. As we learned yesterday, if some of you may have joined that session, workshop your paper, if I may refer to that. And so I hope that this is an opportunity to present it to you, even though I know that I'm in contrast to some other readings of the current jurisprudence of the Court of Justice. So, is that working? Yeah, perfect. So, what is this question about? So this question is about what this topic comes down to. So how do you deal with the plurality of legal and natural persons in competition law? And this topic is very interesting from a theoretical standpoint, but also has some important practical implications. And that can be seen from the recent jurisprudence from the Court of Justice. So for example, in Skanska, the Court of Justice established, among other very important implications, that question of corporate entity liability should be answered similar in public and private enforcement procedures. And that's why I'm doing it here too. And also, as you all probably know, the Spanish court is asking for a preliminary ruling before the Court of Justice, and hereby the liability of the subsidiary is in question for a breach of competition law by the parent company. So there is, again, a vital discussion in member states and on the European level, and we need to find common grounds here, since the effective enforcement of competition law within member states by private enforcement procedures especially might be endangered if we come to different interpretations within member states. So let me briefly show you what I'm going to do today. So I'm going to show you first some national reservations from the German side to this kind of approach the European Court of Justice is taking in order to define what an economic unit is and thereby establish something that might be called an activity approach. And then we have the issue of whether an entity is liable within that economic unit. And here we have a jurisprudence who's talking about liability versus conduct attribution. And we need to see how we're going to solve that issue. And that is something that could also be applied beyond the European jurisdiction. And of course, I have some conclusions for you. So the first issue is the national approach on legal and natural persons within a corporate entity. And the problem is that a corporate entity, as defined by member states law, is defined by member states law, and therefore it is in contrast to what the court is doing with while interpreting or while defining what an economic unit might be under competition law. So what the German jurisprudence as well as scholarship is doing is they're enforcing the principle of legal personality from corporate law, and thereby saying that when the court is defining an economic unit, it might not overcome the principle of legal personality according to national corporate law. And the Court of Justice establishes that the formal separation, like the principle of legal personality, between those companies resulting from their separate legal personality isn't relevant under competition law. And I think the court might have a point here, since there is a well-established jurisprudence for the special treatment of groups under Article 101. And the basic idea here is that there is no agreement unless there are separate entities. So in a case, not every entity is acting autonomously on the market according to its internal rules, we may not apply Article 101. And that is a very established jurisprudence, but what we can learn from it for this question we are actually asking is, so even though there are several entities, each with its own legal personality, there isn't necessarily a plurality of undertakings according to competition law. So what is important here is that we have an economic unit that might consist of different legal and natural persons, and that this framework works independently from national corporate law. So the second issue is how to define the economic unit. And here the Court of Justice is taking this activity approach. Thereby it says that entities that had participated in an infringement form the economic unit. And this own participation of every entity within that economic unit has to be established by proving a de facto control over the market activity itself. And that can be done by a variety of different criteria, for example, economically, organizationally, or legally links. That was established in Evonik, for example, and that is just an example to show you how this de facto control over market activity can be established in a given case at hand. When you talk about how to define an economic unit, most of you probably have the control or decisive influence argument in mind, which is basically saying that, which describes a relationship between the parent and its subsidiary of a corporate entity. And thereby saying that the parent shall also be within that economic unit and not only the subsidiary, due to the fact that the parent is controlling it. And the reasoning goes that one entity that no longer determines its market behavior freely, but acts under the dominance of another entity, so here the parent company. So when we have that situation, then both shall be held liable. However, while this is reasoned and it is established jurisprudence, however, it is just one option to determine who is in command of the market activity. So if you have that control or decisive influence and you can establish it in a given case at hand, then it's only assumed that both entities participate in the market activity. So it's not in contrast to this activity approach, it's just one convenient way to prove that we have participation of both parent and subsidiary in a given market activity. And therefore, we can define an economic unit by a participation of each entity, even if it's an indirect participation. And that's why there is no contradiction to the principle of personal liability due to the fact, personal responsibility, pardon me, due to the fact that we have an indirect but own participation of every entity. And then the third issue is, what do we do within that so established economic unit? Do we have conduct attribution or liability attribution? And there is a divergent jurisprudence. So some decisions say the conduct of the subsidiary may be imputed to the parent company, so it's the conduct that is attributed. And others say the Commission may impute liability for an infringement. So what do we do with that? And here the economic analysis might help. And to do that, we need to differentiate between those two options. So there's the liability of the economic unit as such, and there is the attribution within that economic unit according to the liability versus conduct attribution approach. So for the liability of the economic unit itself, we may apply intentional torts. What is the reason behind that? The reason goes that the injurer, in this case the economic unit, spends resources to commit the wrongful act. And therefore the injurer is the party with the lowest cost to prevent that harm from occurring. So because he just needs to stop spending resources. And then when we say that, then we can say, well, it is economically sound to hold that economic unit liable as such. So it does not help this finding here, which is quite easy to make, to determine which kind of attribution approach is sound within that economic unit. And because time is is short in this presentation, I just refer to why I think that the liability attribution approach is the better choice. And the liability of one entity is then imputed to another within that economic unit. And by doing so, we have a de facto strict liability within that economic unit because we do not need to prove for that second entity any form of fault. And whether strict liability is a sound approach in a given case at hand is well established in the law and economics literature. So there's, for example, the work of Posner, Chauvel, Sykes, and some others within the German scholarship that also are referring to those questions. So what I'm not going to do is I'm not going to reinvent their work. But what I would like to do is apply their findings to the approach I was just proposing here. So with that, I like to come to the attribution issue. So the general principle when it comes to attribution is that in case of various tortfeasors, they shall be jointly and severally held liable. And this phrase here is what the Court of Justice is always referring to when it comes to question of liability. So it is in general sound though. So in case we have by various tortfeasors, which we have, if we have subsidiary and parent company involved, then this is in general sound. It does not so far say anything about whether the attribution of liability or conduct is sound. So therefore we need to see what strict liability is about. And under strict liability, an injurer has to pay damages or fines in any event. So one could argue that if we're applying a strict liability approach, this ruins like every incentive to take precautionary measures due to the fact that you have to pay damages or fines in any event, whether you take precautionary measures or not. However, what we are aiming for in competition law is that we want to prevent any activity from occurring on the market. And therefore, strict liability sets incentives to refrain from an ultra-hazardous activity. And we have then to say that a breach of competition law would be one of those ultra-hazardous activities. So conduct attribution is regulating the level of activity due to the standard of due care, which is further elaborated by the jurisprudence, but strict liability is preventing the activity as such. And since we want to achieve that, the strict liability approach taken by the most recent jurisprudence is sound. And therefore, we have liability attribution within that economic unit, and we may say that that is a sound principle. So in conclusion, we have an undertaking that is defined independently from national corporate law, and therefore also the economic unit is. Then we have that activity approach, which means that participation in the market activity is key in order to establish an economic unit. Thereby, I mean not the control over the entity, but participation in the market activity as such. And then, if we have that, the economic unit as such is in breach of competition law. And within that economic unit, the attribution of liability is sound. And therefore, even the liability of subsidiaries for breaches of competition law committed by the parent company is also sound. And that brings me to the very beginning of my presentation and the Spanish procedure. And here we would say, applying this approach I just proposed, the answer of the court would be, yes, that is possible. So with that, I would like to thank you for your attention, and I'm looking forward to the Q&A.
Thank you very much, Eva, for this very interesting presentation. I would now open the floor to questions and remind you that, Eva, so legal entities are irrelevant. This is the first question to you. And then from Marcos. So,
well, if I could just jump in to explain very briefly.
Yes, thank you. That's appreciated. Thank you.
Well, thank you very much for a very clear presentation. I think it was all set out very, very clearly. But there's also case law of the Court of Justice saying that in order to impute an infringement of competition law, the public enforcement authority needs to identify a legal entity, not an undertaking, to identify a legal entity. Besides 299 of the treaty and the rest of that, there's case law of the Court of Justice repeated since the trade arbet case. You need to say who is the legal entity. Now in Skanska, the problem that we had was that the public enforcement decision had said that a certain entity had to pay for the damages, and the courts refused to apply that decision from the public enforcement entity. I would submit that the case in the Spanish trucks cartel case is exactly the opposite. I mean, the question is whether the courts can make liable someone that was not identified as liable by the public entity. I wonder whether there is still a role for the public entity. I mean, for the legal person, for the corporate vehicle used by the undertaking. I understand that one may want to attribute everything, but I would question that we can disregard entirely legal persons, because ultimately, when enforcing, we will need to identify a legal person.
Yeah, thank you for that question, and that's definitely a very good point. However, I was invoking that activity approach in the very beginning of my presentation. I said that I don't want to impute everything within a corporate entity. So I don't equalize the corporate entity with the economic unit. So what I was saying was that we need an activity approach, or we need own participation of every entity of that corporate entity to be attributed or to form that economic unit. And within that economic unit, then we may attribute liability. But the relevant factor here is that it's still own participation by every entity. So that doesn't make it like that very severe with regard to shareholders' interest, for example. So that's like the common argument that is brought forward all the time. What about the shareholders behind that? So we have the activity approach, its own, so it's the own conduct of every entity that is within that economic unit. So that's first. And second, the court needs to first identify an undertaking and an economic unit in order to apply 101 or 102 of the treaty. And it is a second question for the national enforcers then to set out or to identify the person where they can send the actual paper saying how much fine is to be paid. But that's not a question of primary competition law. It is rather a question of the national approach in order to enforce what is decided under primary competition law.
Right. Great.
If that answers your question.
Yes. Katarina, you have a comment?
Yes, that's me. Hello, I believe yesterday we had already started discussing this issue regarding, and I know you made me this question yesterday about the presence, and I know like the case law in this subject, the court contradicts.
Please, I would ask you to be brief because I'm in the jury for the prize for the best junior paper, so I will have to shift to another room. So you will be more than welcome to stay here in this room and to continue the discussion. But I hope you wouldn't mind if in really 2 minutes I would leave to discuss with the rest of the jury a little few details about the price. Okay, so please go ahead.
Okay.
So yeah, you can also discuss this per email if you want to, so it doesn't need
No, please go ahead. Go ahead.
Okay.
I just ask you to be brief.
But just strictly, yeah, sometimes the court says it doesn't really matter that the entities are present in the same market for them to say that we have an economic unit. What you have to take care is, what you have to consider is control. And then you describe it as a form of strict liability, which I agree. The problem I have is the court has expressly said lots of times it doesn't consider it to be a form of strict liability. And plus, yes, strict liability justifies holding an entity liable for the other, but it justifies because the parent company is able to control and therefore prevent in future behaviors. And so what I mean is, like, I have some problems using the justifications you use for strict liability to justify a subsidiary liable for the parent company. But I mean, it's more common.
No, you're right. I see your point. The question rather is what I do not apply strict liability for the economic unit. What I'm saying is that if we apply this approach within that economic unit, then we have de facto strict liability because we are not asking for another act of fault for the second entity. So I'm not saying that the court is saying it is strict liability. I'm saying it is de facto, economically speaking, strict liability. So I think that's a different approach, though. And then it is asked, is that the right approach? Is that what we want to have in order to set the right incentives on the market? And I would say, with regard to those subsidiary arguments, it is the right approach. And as yesterday also somebody said, it is the corporate entity who bears the cost of allocating risk within its corporate structure. So it's a decision taken by the corporate entity how to organize itself. And therefore, I think the risk coming from this kind of organization, the organization itself shall take care of, or not the market. So for example, if you say it is conduct attribution, then we have a level of due care. And if you reach that, but the harm is occurring anyway, then the market has bear the cost that is coming from what is above that level of due care. So in the other way around, in strict liability, we attribute that in any case. So the market is not the one who has to bear the cost. And I would say you have the advantage of organizing yourself, and therefore you should also be held liable for any harm that is occurring within that corporate structure. And I don't think that this kind of shareholder argument is valid here as I developed earlier, because it's the own conduct of every entity. So it's not every entity within that corporate structure, it's just that one that actually participated in the market activity. And under this premise, I think it is justified to be that strict. But only under this premise.
Thank you very much.
Yeah.
And I thank you all for joining this panel and to make it so lively and so interesting for everyone. If you would like to continue discussing, I would leave the room open. You are co-host, so you can easily do that. I think, yes. Eva, you are co-host, and also the other speakers are co-hosts. You can easily do that. I would leave you here, and thank you very much, and congratulations for your presentation. Bye-bye.